Honorable High Court of Orissa, I, Angswarupa Chatterjee, Civil Judge cum Judicial Magistrate First Class Hemgir, welcome everyone to this inaugural session of the state-level Juvenile Justice Consultation. The quest of today's consultation program is to delve into the discussion of how reformers believed that treating children and adolescents as adult criminals was unnecessarily harsh and resulted in their corruption. The legislation and procedure laid down by the Juvenile Justice Care and Protection of Children Act 2015 pursues the reformative goals of these delinquent children because, as the saying goes, children are not things to be molded, but are people to be unfolded. May I now request Member Secretary, State Legal Services Authority, to kindly escort His Lordship, Honorable Shri Justice Debabrata Das, Judge, High Court of Orissa, to the dais. May I now request Registrar Vigilance to kindly escort His Lordship, Honorable Shri Justice Sangam Kumar Sahu, Judge, High Court of Orissa, to the dais. May I now request Director of Orissa Judicial Academy to kindly escort Srimati Shubha Sharma, Indian Administrative Services and Commissioner cum Secretary, Department of Women and Child Development. My apologies. I now humbly request Director Orissa Judicial Academy to kindly escort Shri Keshav Kumar to the dais. May I now humbly request Registrar Inspection to kindly escort Mr. William Hanlon Jr., Chief of Field Office for Orissa, United Nations International Children's Emergency Fund, to the dais. May I now request Coordinator Arbitration Center to kindly escort Srimati Mandakini Kara, Chairperson, Orissa State Commission for Protection of Child Rights, to the dais. On this day, we are also fortunate to have amongst us His Lordship, Shri Justice Shubhashish Talapatra, Chief Justice, High Court of Orissa, and His Lordship, Shri Justice Chittaranjan Das, Judge, High Court of Orissa, who, despite of their busy schedule, have graced us with their benign presence through virtual mode. We are also equally privileged to have the august presence of all the honorable judges of the High Court of Orissa, who have graced this event through virtual mode, members of the registry, all judicial officers and other office bearers, members of the print and electronic media, and other distinguished dignitaries and revered guests who are present today on this auspicious occasion. I now seek the permission of the Chair to declare the inaugural session of the state-level Juvenile Justice Consultation as open.
Yes.
Thank you, my Lord. The session is declared as open. I now request all the dignitaries on and off the dais and the audience to kindly rise as a mark of respect for the rendition of the state song, Bande Utkala Janani.
Bande Utkala Janani, Bande Utkala Janani, Charu Bhasamai, Charu Bhasamai, Janani, Janani, Janani. Suso
Thank you all. Yatha Suryastha Jnanam. Knowledge is like light as it drives away darkness, which is ignorance. A lamp is a mark of auspiciousness, and to make this event a blessed one, we would like to invoke the Almighty at the very onset of this event. Now, I request their lordships to kindly light the ceremonial lamp and spread the divine grace. I also request all the dignitaries on the dais to join the lighting ceremony. Thank you. May I have the proud privilege to request His Lordship, Honorable Shri Justice Debabrata Das, Judge, High Court of Orissa, and Chairperson, Juvenile Justice Committee, to kindly present the welcome address. Please, my Lord.
A very good morning to all of you. My Lord Honorable Justice Subhasis Talpatra, the Chief Justice of Odisha High Court, Senior Brother Judge, Dr. Justice Vidut Ranjan Sadangi, Brother Justice Sangam Kumar Sahu, my esteemed brother and sister judges of our High Court, Dr. Panda, Mr. Panda, the Director, Mr. William Hannion, Junior Chief of Field Office of Odisha, UNICEF, all judicial officers present, members of the registry, delegates from different institutions and organizations. Friends from the media, a very warm welcome on this auspicious moment. A bare reading of the preamble of the Juvenile Justice Care Protection Act 2015 would show that the entire piece of legislation has been drafted having regard for the salutary constitutional obligations that our welfare state has under different articles of the Constitution made to protect the rights of juvenile who has been defined as a child below the age of 18. Therefore, when we talk about ensuring care and protection for the juveniles, it is essential, something more than a statutory obligation. The Juvenile Justice Act is a social welfare legislation, and we, however, often call it to be a penal legislation, which is not correct. This legislation aims to achieve certain laudable objects like consolidating the laws relating to the children in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social reintegration, and more importantly, through adoption of a child-friendly approach in the adjudication. It further provides the ways and means to ensure disposal of matters in a way which is in the best interest of the child, and for rehabilitation. The rise of juvenile crimes at a considerable rate is really worrisome for the consequences that is befalling. The National Crime Record Bureau, in its 2021 report, has pointed out that a total of 31,170 cases were registered against juveniles in 2021, which shows a hike of 4.7% from 2020, when the figure stood at 29,768. Even more notably, it is being found that juveniles are mostly accused of crimes like drug peddling, sexual assault, and murder. When we reflect upon such crimes, it is more than apparent that a number of social, educational, and family factors are responsible for commission of such crimes by a portion of the young citizenry of the country. This psychological assessment would show as to how they are entangled in the vicious and hardly escapable cycle of these heinous crimes and under the control of the kingpins. Section 214 of the Act defines child in need of care and protection. Under subsection 12, number of situations have been illustrated where a child can be considered as a child in need of care and protection. These are the concepts like fit facility, foster care, foster family, group foster care, and open shelter. These are some of the terms which are unique and have been thought of as modes of rehabilitation of child who has been found to be in conflict with law. Some very interesting questions have been raised across the country in India, about various provisions of the Juvenile Justice Act. Whether a juvenile is entitled to anticipatory bail under Section 439 of the Code of Criminal Procedure. That has been, of course, answered by our High Court in the affirmative that yes, it is. Recently, the Honorable Supreme Court of India was confronted with a situation whether the provision of Section 436A of the CRPC would be applicable in such cases, which says that where a person has undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for the offense, he shall be entitled to be released by the court on his personal bond with or without sureties. The question, however, has been left open to be decided in appropriate cases. While conducting trials, often a question crops up before the trial court as to whether a person under the age of 18 years who has committed a very dastardly crime should be tried as an adult or as a juvenile. Answers to these critical questions are somehow hidden in the statement of objects and reasons of the Act. Further, peculiar circumstances of the cases are needed to be carefully assessed by the courts to arrive at a just and judicious decision. On this decision, we actually start the adjudication process on which it depends, future of the juvenile depends. Regular discussions and deliberations among the stakeholders and authorities under the statute are absolutely essential for effectively achieving the goals that have been provided under the Act. This consultation assumes a huge significance as we have invited most vital grassroots stakeholders to come together, and through this program, we intend to provide them a platform where they can deliberate upon the pros and cons of the system which exist as on the date. We hereby welcome them to flag the issues which are posing hindrances in the implementation of the Act. We have prepared a promising agenda for the consultation program, which seems to be exhaustive and in more ways than one would provide opportunities to all of you to come forward and discuss the most critical issues faced by you in the day-to-day dealing with juveniles. The Constitution of India stresses the most on the individual liberty of the people. And when it comes to the minors, the strictures are even more stricter. Suggestions have been made by different authorities at various times for the least infringement upon the personal liberty of the juvenile offenders. Therefore, in this program, we will be discussing about an ambitious aspect as to how we can balance the need of the society vis-a-vis the juveniles by less adverting to the custodial detention of such offenders. You people are encouraged to give your valuable suggestions regarding alternative ways that can be resorted to as provided under law other than the detention of the juveniles in custody. Much greater emphasis is needed to be given to the issue of rehabilitation of such offenders, and such rehabilitation must ensure their full and effective return to the social mainstream as valuable members of the society. I'm sure that today's consultation would be wholly meaningful, and with the contribution of each of you, we will accelerate our movement in the right direction of fulfillment of the objectives set forth for achievement under this beautiful piece of legislation. I once again welcome you all to this consultation and wish all the best in you to come to surface in the sessions to come. At the end, I again extend my thanks to my Honorable Chief Justice, Justice Subhasis Talpatra, for having given kind consent to join us virtually by remaining at Raurkela with Honorable Justice C.R. Das. Thanking you once again, I welcome all of you to this consultation. Bande Utkala Jajani.
We all thank you, my lord, for the warm welcome extended to our honorable guests, along with your words of wisdom. May I now request Mr. Keshav Kumar, retired officer, Indian Police Services, to kindly address this illustrious gathering. Please, sir.
A very good morning to all of you. I'm very happy to be here. Honorable Sri Justice Subhas Talpatra, Honorable Chief Justice, Honorable Sri Justice Debabrata Das, Honorable Sri Justice Sangam Kumar Sahu, Srimati Mandakini Kar, and Mr. William Hanlon. I'm very happy to be here today in midst of such luminaries and as a cop who served in the police department for 35 years. I'm here today to share some of my thoughts. I remember in the year 1991, when I was SP of a very historical district called Kheda. If you have heard about Kheda Satyagraha. So I was 133rd SP of Kheda. In my jurisdiction, the session judge of Amreli district, she had her ancestral home. And one fine morning, I get a call from her. The SP Sahab, you know, my house has been burgled in your jurisdiction. And she was from a royal family. She had very many old utensils of silver, and number of silver utensils were missing. You know, as a young SP, it was a testing time for me that the house of a session judge gets burgled. I put my best of the staff for the job. I personally visited the scene of crime and used all the techniques that I had learned at the National Police Academy. But there were absolutely no sign and symptom of any entry point. This was baffling us. And the dog squad used to come and just roam about and go into the lanes. You know, at that point of time, whatever forensics that I had learned at the National Police Academy, I put each and every forensic technique to use, but there was absolutely no scene. At that point of time, I thought there could be some entry point here somewhere. And when I was returning from the scene of crime, I found some children, you know, flying kites. I generally happen to just stand by and ask them, any idea about who has burgled this? So one child came running to me and he told me, sir, usko pata hai, usko pata hai. Then I thought I should not interrogate a child. So I used one of my lady sub-inspectors. उस बच्चे को आप लेके आओ and just talk to him. And, as it would be, the lady, myself, I'm really grateful to her, Sharmistha Bain. In Gujarat, we call Bain. So Sharmistha Bain, she interrogated the child and she was able to tell us the whole story. कि सर इन्होंने चोरी कैसे किया? Actually, the story goes that, the house, on the roof, there was a ventilator. And what these people used to do, the elder ones, he was about 10, 11 years old. What they used to do, they used to climb the roof and open the ventilator, and they would tie a small child, about 5, 6 years old. They would tie it to the waist, and he would be lowered inside. He would go inside and pick up all the things. So it was very startling. So finally, when we entered the room from the roof and we opened, there were lots of perfume in the room, too much of smell of perfume. And we felt as if, somewhere had swept the floor. Thereafter, after interrogation of the small children by Sharmistha Bain, the younger child used to say, sir, I used to carry a perfume bottle with me. And I used to carry a wet cloth in my hand. So when I was pulled up, I used to spray the perfume. And before being pulled up, I used to sweep the floor. I said, why did you do this? Then he said, वो राजू भाई है ना, उसने बताया था कि dog squad आता है. That is why before coming out, I used to spray perfume so that the dog doesn't get the smell. And secondly, he used to say that, sweep क्यों करते थे? तो सर वो fingerprint आ जाता है ना. That is why we didn't want any fingerprints there. So this was my first interaction and first brush as a young SP in 1991. And from there started my journey into juvenile justice. And thereafter, wherever I went in the districts, I used to ensure that whenever we get, that time the JJ Act was not there. And I was very sensitive to this issue. Thereafter, I joined the organization called Prayas, a Delhi organization, and worked for the juvenile justice. I'm very happy to be here today, chiefly because, I would like to share some of my experiences. And presently, my passion is forensics. And I would like to use those forensic techniques. I'm also doing PhD in forensics from National Forensic Sciences University. And I would like to use my knowledge vis-a-vis the investigation of the children in conflict with law. I would be sharing my thoughts, and I'm very happy to be here, especially with the legal luminaries that I would be sitting and interacting today. I thank you, all of you, for inviting a COP to deliberate on this issue. Thank you so much.
We thank you, sir, for sharing your journey on juvenile justice and your enriching experiences with us today. At this juncture, I would like to invite Mr. William Hanlon Jr., Chief of Field Office for Orissa, United Nations International Children's Emergency Fund, to kindly share his thoughts on this venerable event. Please, sir.
Thank you. Honorable Mr. Justice Subhasis Talapatra, Chief Justice, High Court of Orissa. Honorable Mr. Justice Deepa Brata Das, Chairperson, Juvenile Justice Committee, High Court of Orissa. Honorable Mr. Justice S.K. Sahu, Member, Juvenile Justice Committee, High Court of Orissa. Respected Ms. Mandakini Kaur, Chairperson, Odisha State Commission for Protection of Child Rights. Honorable judges of the High Court and members of the Juvenile Justice Committee present today, distinguished speakers and resource persons, senior officials and members of Odisha High Court, senior officials of WCD, police and all other line departments, principal magistrate of JJBs, and all participating officials in line departments and CSO members. Namaskar. A very good morning and warm welcome to you all. First, I would like to congratulate the Juvenile Justice Committee of the High Court of Orissa with the Odisha Judicial Academy and the Department of Women and Child Development for organizing this consultation to discuss and have dialogue on a very important agenda. I encourage your active participation in the consultation. Please share your thoughts, ideas, experience, and key concerns. Each of your views are important to foster collective learning. It is inspiring that the Honorable Supreme Court and the Honorable High Courts are encouraging us to embrace new approaches to secure justice for our children, to ensure that the path of justice for children is paved with compassion, fairness, and rehabilitation. With this context, I would like to explore 5 key agenda areas of this consultation. First, prevention of child offending. We must shift our perspectives from merely addressing the aftermath of juvenile offenses to focusing on prevention. By investing in education, community programs, and social support systems, we can create an environment that reduces the likelihood of children returning to criminal activities in the first place. This is a low cost, effective, and it makes programmatic sense. Second, diversion, alternatives to detention and non-custodial alternatives. We need to acknowledge that every child in conflict with the law requires a rigid formality of justice system. Diversionary measures allow us to address children's issues without resorting to punitive measures. Third, rehabilitation and restorative practices. Instead of focusing solely on retribution punishment, we should prioritize rehabilitation and restorative practices. By providing avenues for these young individuals to take responsibility for their actions and make amends, we can help them reintegrate into society as responsible citizens. Fourth, right to a fair child and child-friendly procedures. Children, like all individuals, have a right to a fair trial. Child-friendly procedures and legal assistance are essential to ensure their rights are protected throughout the judicial process. Fifth, rehabilitative and restorative practices. These hold immense power in transforming the lives of young individuals who have ventured off track. By focusing on their emotional and psychological growth, we empower children to acknowledge their mistakes, make amends, and rejoin society as responsible citizens. So with that, I would like to thank you again, and I wish you a very good and successful day in these consultations. Thank you very much.
We thank you, sir, for your refreshing take on social support systems, justice, and restorative practices. May I now request Srimati Mandakini Kara, Chairperson, Orissa State Commission for Protection of Child Rights, to address the gathering on this hallowed occasion. Please, Madam.
जय जगन्नाथ। बच्चे मन के कच्चे और सच्चे भी होते हैं। नमस्कार। Thank you, sir. Welcome to Chief Justice, Honorable Chief Justice Subhasis Sarji, and Juvenile Justice Committee Chairperson Devabrata sir, Honorable Sir Sangam Kumar sir, and Keshav Kumar sir. Thank you all. The Child Rights Commission in Odisha assumes a pivotal role in the protection and preservation of the rights and holistic welfare of the children. The Commission works closely with and monitor various departments, including Women and Child Development Department and organizations that work on issues of children, and thus upholding the governor's commitment to ensure the rights of all children in the state. The Commission's role is particularly crucial in preventing children from becoming involved in the situation that might them to become children in conflict with the law. Our primary aim is to prevent children from the entering situations that might lead to legal conflicts. We use multifaceted approach involving advocacy, awareness, and education. By promoting a strong understanding of the child rights among children, families, and communities, we strive to abort circumstances and could push children into a state of conflict with the legal system. Vigilant monitoring and timely reporting will access children's well-being across the state, identifying vulnerabilities and proactively addresses potential human rights violation. This proactive stance helps create an environment that discourages children's engagement in criminal activities. Here, efforts are directed towards addressing underlying issues, providing education, skill development, counseling, and intervention for successful reintegration. The department WNCD has established 7 observation homes, 7 special homes, and 1 place of safety for their correctional measures. Presently, in total, 218 children in observation homes, 15 in special homes, and 102 in in place of safety. These facilities offer diverse activities, including informal education, vocational training, counseling, and art therapy for emotional processing. Cultural events like dance and debates foster holistic development, social integration, and among children. In all our efforts, we strive to shape a future where children's potential prevails over past mistakes. Strengthening and preventive and redressal measures through child rights awareness camps, promoting diversion program, restorative justice implementation, encouraging the adoption of restorative justice practices where there is a children take responsibility for their actions, make amends, and restore harm caused through a victim offender meditation method. Advocating and acting for the establishment of a non-custodial alternatives to detention, such as group homes, supervised probation, and community-based rehabilitation centers to provide a more rehabilitative environment for children. In conclusion, the Odisha State Commission for Child Rights of Children is dedicated to creating a protective and nurturing environment for our children. Through advocacy, collaboration, education, and sound policy, we aim to prevent children from entering the juvenile justice system due to conflicts with the law and proper rehabilitation of such children at community level. We strive to give them a chance where they can improve and create a future of their own, learning and moving from their mistakes. Thank you, sir. Can I say something, but not about this topic? Sir, please, 1 second. Today I am facing a lot of problem here. Sir, please. Today, as a 6 months old baby daughter, I am today here. I am facing a lot of problem. So I request to all JJC committee members, please, if a space available, can you for breastfeeding like children's, not like this, only judicial academy, like airport, railway station, courts, and collector office. Because like me as a mother, others are here present. So as a mother, I am grateful to you. This. Thank you, sir. Jai Jagannath, Bande Utkal Janani.
We all thank you, madam, for your discussion on the government's role in protecting children and promoting awareness and counseling.
Thank you, sir.
May I now have the honor of requesting His Lordship, Honorable Shri Justice Subhashish Talapatra, Chief Justice, High Court of Orissa, to deliver the inaugural address. Please, my lord.
Good morning to all. From a far distance, I am addressing you through video conferencing, and I like to be excused for that, being away from the main heartthrob of the conference. Justice Devobrato Das, the chairman of the Juvenile Justice Committee, High Court of Orissa, Sri Keshav Kumar, the former Indian Police Service officer, Mr. William Hanlon Jr., Chief of Field Office for Orissa UNICEF, Srimati Mandakini Kaur, Chairperson Orissa State Commission for Protection of Child Rights, Justice Sangam Kumar Sahu, Member Juvenile Justice Committee, High Court of Orissa, my esteemed colleagues, registry officials of the High Court Legal Services Committee, State Legal Services Committee, and the officers of the Orissa Judicial Academy, ladies and gentlemen. I express my heartfelt gratitude to the organizers of the state level juvenile justice consultation on a very important issues is, as briefly stated by William Hanlon Jr., these are very important issues, and the core in the issues is in the problem. The entire legal system, administrative system, and support system we have created over the years is grossly inadequate in comparison to the problem relating to the juveniles. There are two issues is initially comes through our mind is, first of all, care to the children who is in need of the care, and secondly, to give the justice to the children who are coming in conflict with law. As a member of the judiciary, we are dealing with the justice part of this problem. And there are certain issues which requires to be flagged and highlighted in today's consultation. Because the principle number 1 is stated by Mr. Hallon, that prevention of child offending becomes a part of the juvenile justice. I'm grateful because it is an entire process. When a child is brought to the process of justicing, they met first with the police officers. Mr. Keshop Kumar was illustrating an experience of his early career. And there are two parts in the story regarding this child who was somehow involved with an offense. First decision is a laudable. He says that I will not interrogate the child. And that should be the approach at the first instance. But the second decision, which is very rampant, that the responsible officers do not have the conversation with the child. They send their subordinate officer to talk to them. And in most of the cases, I can say they are not trained how to have even the conversation with the child. And Mr. Kumar has rightly said, I sent that lady police officer, and the lady police officer, I quote, interrogated the child, where I object. No child should be interrogated, because part of the interrogation is bullying the child, and that damages the child's psychology further and make him a very resistive to the sensitive handling of the justice processing. And we should sensitize our police officer only to have conversation in a very gentle and mild manner. And when they're produced before the Juvenile Justice Board, or for any instance, if there is a confusion about their age, to the court, there's just the duty of the judicial officers, judges. It is my experience. I do not blame anyone. It is useless to blame anyone. That our judicial officers are also not properly trained how to just continue the inquiry. I don't say this is a trial. When they are just allowed to be with the adult criminals before they are segregated to sending them to the Juvenile Justice Board. I would request all the judicial officers, please don't do that at all. At the very beginning, give them the due honor, because we know they are not grown-up humans. They are intellectual faculties are not developed. They do not know actually what they are doing. I know there will be immediately response from some people that we have seen some juveniles. As Mr. Kumar was telling that the young girl was this sweeping out the marks, traces from the floor, and that idea was given by the offending child. These are the aberration and exceptions, and sometimes these copied behavior. Therefore, that cannot be made the ground for formalize our procedure. Please, so many things depend upon us because so many areas are not codified, procedure are not elaborately laid down. All depends our individual approaches, how we do handle the juvenile justice process. Second time, most of the inquiries that held the Juvenile Justice Board, children are not allowed to speak out. Please recognize their right to speak to the trial. Create that environment in the Juvenile Justice Board so that they can feel free to talk to the members and the principal magistrate of the Juvenile Justice Board. They can speak that in what circumstances, how they are led to this offending. This is very important. And generally, I'm coming to the other parts that Ms. Srimati Mandakini Kaur has mentioned one thing at the end of his speech, that the supervised probation, does it happen in our society or in our system? This should happen. Because we must adopt a policy of least detention and allow them to go back home, or a homely situation. There may be supervision by the probation officer, but that system are not. That is the reason I was urged this consultation. Think of a ecosystem and which is interactive, and it is intercoordinated amongst all stakeholders. Something happens with the Department of Child Welfare. I brought this thing, their departments under very nomenclature in various states. They do not know what is happening in the Juvenile Justice Board. They do not know what the representation in the board they have selected, how they are performing in the board. Similarly, the body created under the Child Rights Act, the Commissions for the Protection of Child Rights, they are supposed to function as an oversight body. And most of the time, their presence is felt by us by their conspicuous absence in the entire process. They have become, unless a complaint is filed to them, the entire institution that has been created under statute is not activated. The reverse should happen. They should be active. What is happening about the children? They should be active, that whether the body is created under the statute, the administrative setup created to look after the welfare of the children are working properly at the grassroots level. Few years back, I had an idea. I was sharing with my state government, the state from which I hailed, that the Anganwadi center should be renamed as the Child Welfare Center. And those centers should be an umbrella set up in the village level to look after the children at distress, children who are not getting proper education, children are deprived of the proper health care, children who needs guidance. So that should be a comprehensive center. This requires a policy change. But I should say, this is the consultation with this kind of the lapse and the gaps in the system should be highlighted so that we can quickly fill up those and address those gaps. Just I will make that one observation made by a study which says that using deprivation of liberty in cases of girls and boys in conflict with the laws at the pre-trial, trial, and the post-trial stages as a measure of last resort, and for the shortest appropriate period of time will avoid unnecessary suffering and stigmatization of the children and their parents, families, will decrease the chance of re-offending, avoid excessive costs of deprivation of liberty, and increase children's constructive role in the society. So aptly put these words. If we just expand and elaborate it, we can find out what should be our duty as the stakeholders in preserving the right and the liberty of a child. This is very important. That about the very conventional attitude, whether we are a judge or we are the other stakeholders, when a child comes into conflict with law, we start treating him as an accused, as if he's an adult accused. And in this regard, because I am not the authority how the neural development happens, I am quoting an authority on the basis of the neuroscientific research. We know that the neurocortex, the portion of the brain responsible for reasoning and self-regulation, is the last part of the brain to develop. This is why excessive risk-taking and impulsive behavior are typical in adolescence and often lead to the commission of offenses. The other studies have shown that the experience of toxic trust, that is a new phenomenon our society is now facing, in early childhood can result in abnormalities in the structure and the chemical activity of the brain. Recent systematic reviews of evidence across a range of international contexts consistently reveal high levels of neurodevelopmental disorders among the incarcerated young people, with rates that are grossly disproportionate to the equivalent levels among the general youth population. Therefore, I should stress the jail is not, or the detention is not the alternative for the juvenile justice. We are to think of the diversions and alternative measures to the judicial proceeding and detention, which are proven to be the more effective, not only from the rights perspective, but also for the expenses we carry out. Costly buildings are not sufficient unless these buildings are used for the restorative justice, being for recycling the child to a healthy life where he can grow as a complete human being. That is a huge start. And all these literatures, conventions, we are all aware of, becomes the mere dead letters unless we put life into them. And with these few words, I again hope this consultation will be very effective, and the recommendation that will be made will be taken seriously by the stakeholders, and whatever is possible on behalf of the High Court of Orissa, that shall be done under the leadership of Justice Das, who is doing a wonderful job all through. And I thank you all. Thank you everybody who are participating in this consultation. The expert will be taking their views forward in the technical sessions. I hope the technical sessions would be also fruitful and very attractive and thought-provoking. And that also break, I think, the new areas of our thought. Thank you, everyone.
We thank you, my lord, for highlighting the key parts of the procedure and the approach to be taken while dealing with children in conflict with law, the need to protect children from interrogation, and the urgency of sensitizing police as well as judicial officers. I now humbly request His Lordship, Honorable Shri Justice Sangam Kumar Sahu, Judge, High Court of Orissa, and Member, Juvenile Justice Committee, to kindly deliver the vote of thanks. Please, my lord.
मैम मंदाकिन कर ने जिस लाइन से अपना एड्रेस शुरू किया था, मैं उसको थोड़ा आगे ले जाता हूँ। ये एक बहुत पुराने हिंदी फिल्म का गाना है कि बच्चे मन के सच्चे, सारे जग के आंख के तारे, ये वो नन्हे फूल है जो भगवान को लगते प्यारे। बच्चे हमारे सबसे मूल्यवान प्राकृतिक संसाधन है। बच्चों की हंसी में ईश्वर की खुशी होती है। बच्चे हैं तो गलतियां तो करेंगे ही, कभी छोटे कभी बड़े, लेकिन getting angry and yelling at the kids for making mistakes, in my humble view, it doesn't teach them not to make mistakes, but it teaches them to hide the mistakes. Honorable Justice Subhasis Talapatra, my Chief Justice and Patron-in-Chief, Odisha Judicial Academy, my esteemed brother, Justice Debabrata Das, Chairperson, Juvenile Justice Committee, High Court of Orissa, Mr. Kesav Kumar, retired IPS officer, Mr. William Honlol Jr., Chief of Field Office of Odisha, UNICEF, Srimati Mandakin Kaur, Chairperson, Odisha State Commission for Protection of Child Rights on the dais, my esteemed sister and brother judges of the dais, and those who have joined on virtual mode, members of Registry, Odisha High Court, Director in Charge, Odisha Judicial Academy and his team, Member Secretary, Odisha State Legal Services Authority and his team, members of all the stakeholders, principal magistrates, Juvenile Justice Board, secretaries, District Legal Services Authority, Commissioner cum Secretary to Government of Odisha, School and Mass Education Department and Department of Health and Family Welfare, and all the dignitaries of the state, officials from UNICEF, program managers and field officers, members of print and electronic media, ladies and gentlemen, a very good morning to all of you. It gives me immense pleasure to propose vote of thanks on this memorable occasion of state-level juvenile justice consultation to all the distinguished guests. First and foremost, sir, I express my deep gratitude to my Chief Justice, Honorable Justice Subhasis Talapatra, with the chief guest of the inaugural session and joined us through virtual mode and delivered such a wonderful address. Sir, your speech was really mesmerizing and meaningful. It has created a lot of enthusiasm among the participants of this state level consultation. Everybody appreciates your dynamic personality, your leadership qualities, and your encouragement. Your tireless effort to take the Odisha judiciary to the top will definitely show good results. People of Odisha are immensely benefited to get a personality like you as the Chief Justice of Orissa High Court due to blessings of Lord Jagannath. They have now complete faith on the justice delivery system, sir. Under your guidance, this state level consultation will definitely be a grand success and achieve its objective. Thank you, sir. I thank my esteemed sister and brother judges, specifically the Justice D. Das, Chairperson, and other members of Juvenile Justice Committee of High Court of Orissa for showing their keen interest and dedication for the success of this state level consultation, which was the idea floated by our Honorable Chief Justice. My heartfelt thanks to all the stakeholders for their benign presence on this occasion, the unflinching support and coordination shown by the state government and the UNICEF for this state level consultation deserves a big clap. I would like to thank all the participants who are present here, and I hope that all of you will actively participate, listen carefully to all the eminent speakers who will enlighten us on different topics selected for different technical sessions, which are very important in the present scenario. We hope that you will also give your valuable suggestions and feedbacks. I thank the members of print and electronic media for covering the state level consultation. An event of this dimension cannot happen overnight. The wheel started rolling months in advance, and we have been fortunate enough to be backed by the registry of the Orissa High Court, Director in Charge, Orissa Judicial Academy, and his team of very motivated and dedicated persons who have put tremendous efforts for making this state level consultation a grand success. All of you enjoy the pleasing weather of the Millennium City of Cuttack and this function. Once again, I thank one and all of you for taking time to be here today. Thank you. Jai Hind, Bande Utkal Janan.
Thank you, my lord. May I have the permission of your lordship to declare this inaugural session as closed? Thank you, my lord. The event is now closed. I now humbly request all the dignitaries to kindly proceed to the portico for the group photo session. I also request the honorable dignitaries and participants to assemble at this auditorium for the commencement of the first technical session at sharp 10:40. Thank you all.